to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing.
Welcome back, everyone. Today we're stepping into one of the most chaotic courtroom moments you'll ever witness. We're watching Shayna Blackshear, a self-proclaimed sovereign citizen who believes the rules simply don't apply to her. From the very start of this sentencing hearing, she talks over the judge, interrupts officers, and refuses to acknowledge court procedure. Her arrogance and volume are being tested against real authority. And spoiler alert, the courtroom doesn't bend. By the end, the judge delivers a sentence so firm it leaves no room for fantasy or escape. Buckle up, because this isn't just a legal proceeding. It's a crash course in courtroom reality colliding with an...
No, come on out. This is the date and time set for sentencing. The records show the presence of the defendant. Our advisory counsel is here. And Mr. Wagner, are you appearing before the state?
Yes.
This is the date and time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now.
Okay.
Listen to me. Is your true name and your complete name Shayna Marie Blackshear?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209. Count 1, unlawful flight from a law enforcement vehicle, a Class 5 felony. This is in violation of ARS 28624C.
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622. ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801. The date of the offense was on or about February 5th, 2022. The offense is non-dangerous, and I'm finding it non-repetitive for reasons I'll state on the record. Count three, that she is guilty of count 3, criminal damage, a Class 1 misdemeanor. It's in violation of ARS 13-1602A1, 13-1601, 13-707, 13-802. And she's also guilty of count 4, burglary in the second degree. This is a Class 3 felony in violation of ARS 13-1507A, 13-1501, 701, and 702, and 13-801. The date of the offense was on or about February 5th, 2022. Judgment of the court that she's guilty of count 5, resisting arrest, a Class 6 felony in violation of ARS 13-2508, A1, 13-701, 702, and 13-801. The date of the offense was on or about February 5, 2020.
Excuse me, advisor. Why is they allowed to do such things?
2022. The offenses are non-dangerous and non-repetitive. The reason I'm finding them is the microphone off, Louis, by the way. Turn it on.
Excuse me, that's illegal. Y'all can't do that.
No, that's on now. Turn it on.
Yes, it is, Justice.
All right.
Judge immediately sets the tone, confirming presence, advisory counsel, and proper procedure. This is a standard step, but it's crucial in highlighting the contrast between the courtroom's structured order and Ms. Blackshear's complete disregard for it. She interrupts, claims lack of jurisdiction, and essentially tries to argue that laws don't apply to her. For viewers, this is a perfect illustration of the clash between personal belief systems and legal authority. While she perceives herself as empowered, the judge calmly asserts jurisdiction, showing how professionalism, experience, and procedural knowledge always have the upper hand in a courtroom setting.
So the offenses are non-dangerous. I'm finding them I'm finding you're your own lawyer. He's not your lawyer. He's nothing can do it. I'm finding that they're non-repetitive because I believe that these cases, all of the charges in this case and in CR 2022-208, which is the prior case for which the defendant was convicted, These cases all those charges could have been brought together and tried together, but they weren't. I'm not criticizing the decision. It is what it is. It happened for independent reasons, but I'm finding that they are not repetitive. All right. So, Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
I refuse to proceed.
And if the victims wish to be heard, we have victims here in the courtroom. A victim, I think. I'm not sure.
No, Your Honor. She's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire, I believe that these are repetitive and that she should be subject to the Category 2 repetitive offender statutes. She committed these crimes. She was taken into custody for the first crimes, the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond. And then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was something to clarify up front.
This is illegal.
I believe that it's more than warranted. She was sentenced. Those were separate cases. She was released from those cases, and she committed the new cases. Not only did she commit these crimes separately from the other crimes, these crimes significantly, especially the burglary, I believe substantially affected the victim. The victim, the owner of the property at Morningstar Ranch. Yes, she was burglarized before. No real property was taken from there. As you heard, you sat through both trials. But in this case, in this burglary here, count...
Let me out of here. I don't have to proceed with this. Move. I don't have to.
Count 4, Your Honor.
Let me out now.
The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
I'm sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her out? You're not? Okay.
But I don't want to be in here.
Staying in.
Requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement...
I stand by. Apparently they're going to restrain her and bring her back in. Thank you. All right. All right. Defendant is back. You may continue, Mr. Wagner.
Thank you, Your Honor. I would also point out to the court that count 1, the unlawful flight from law enforcement, and count 5, the resisting arrest counts, are not in any way connected with the prior the 208 case. They're separate victims there. These are definitely separate incidents. The state would argue that as well for count 4, the burglary, Your Honor.
No, I'm not relaxing up in the legal. The court lacks jurisdiction over the subject matter. Y'all don't have no right. Get this shit off of me.
At this point, it becomes clear that this behavior isn't spontaneous. Ms. Blackshear's interruptions, defiance, and attempts to monopolize the courtroom are signs of deeply ingrained entitlement. Viewers should note that no one wakes up one morning thinking they are above the law. This is a learned pattern, reinforced over years of echo chambers and self-validation. The courtroom exposes these patterns in real time, forcing fantasy to meet reality. Every interruption, every claim of illegitimacy, and every defiance chips away at her credibility, while highlighting a simple truth. Courtroom rules are non-negotiable, and failure to follow them has immediate consequences.
If I could have just a second, Your Honor.
I ain't never been biting with y'all.
What's the statutory reference to the 2-year enhancement? I can't remember that.
It is, I'm sorry, Your Honor, it is 708D, and I don't know that I made that entirely clear, but it just, whatever the sentence, the court prescribes, each sentence gets a 2-year enhancement.
Is that ARS 13-707?
Yes, I'm sorry, ARS 13708.
It's illegal.
But not as to the misdemeanor, obviously.
Not as to the misdemeanor. I concur with the misdemeanor assessment that probation had, that it's just time served in the county jail, that she's already fulfilled more than the requirement for that. I agree that the presumptive terms are warranted in the other cases as well, Your Honor. I would point out that the jury during the aggravation phase, the jury found 4 aggravators. They found 4 aggravators. We have no mitigators here that I can see. Even with all of that, I would still ask for the presumptive terms as a Category 2 repetitive offender with the enhancements for the 13708D. I think that these charges probably would be warranted to run concurrent with each other, but I do feel that they should run consecutive to the defendant's prior case. She caused more harm and more emotional stress to the victim, the owner of the property, and then we have separate victims as to the resisting arrest charge and the fleeing from law enforcement charge, Your Honor. I don't have anything more to add than that, and there's no victims present. There's some representatives, some neighbors, some people from the Morningstar Ranch that are still living in the area. They're present here today just to watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release, and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the 2nd degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. The court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years as to count 5.
Here we see a critical procedural point. The victims weren't able to attend due to the defendant dragging out the hearing. Courts are required to protect victim rights, ensuring they have the opportunity to speak. Yet Ms. Blackshear's tactics directly interfere with that process. This is where chaos in the courtroom becomes more than theatrics. It has real consequences. Watching this unfold, you can appreciate the delicate balance judges must maintain between due process for defendants and protecting the rights of victims. It's also a stark reminder. Manipulating procedural delays doesn't grant immunity. It just heightens scrutiny and frustration from the bench.
The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the 2nd degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes The sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for your arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208, do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the cost of an attorney to represent you on appeal. That will include the cost of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and it's a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay. You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence.
How much
What?
time?
Hold on a second. What?
How much time did you give me? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case. She's consistently throughout all the proceedings in the Justice Court and in this court as to whenever required to do so or asked to do so, refused to sign anything. So that would be fruitless to ask her to do that. But the record will reflect that I've advised her of her right to appeal, the right to have an attorney represent her on appeal, and I think that's all I'm going to do. And I don't see any point in having her trying to sign these documents. That's just not going to happen.
I don't either.
I think it'd just be disruptive to the court proceedings. Okay. Anything else? All right, we're adjourned. Thank you.
And here's the dramatic turning point. The defendant spirals into a full meltdown. Her protests, refusals, and erratic behavior require 7 officers just to maintain order. For viewers, this is a textbook example of how unchecked defiance escalates into chaos. This isn't courage or principle. It's a complete loss of control. The courtroom becomes a stage where authority is physically enforced. 7 trained professionals diverted from other duties shows the real-life cost of her fantasy world colliding with reality. It's exhausting to watch, but it's also instructive. Disruption carries consequences, and no matter how loud or confident someone is, legal authority will prevail.